For well over a century, the United States Supreme Court has held that the 14th Amendment prohibits racial discrimination only by state and local governments, not by private parties. But starting in the early 1960s, the court started ruling that if a state government was significantly involved with a private entity, the 14th Amendment might prohibit that private entity from discriminating. The court then considered state repeal of anti-discrimination laws in the 1967 case of Reitman versus Mulkey. Between 1957 and 1963, the California legislature enacted anti-discrimination statutes prohibiting racial discrimination in all places of public accommodation, businesses, and in the sale or rental of housing. But then in 1964, voters adopted Proposition 14, which created Article 1, Section 26 of the California Constitution. Proposition 14 prohibited the state or local governments from denying property owners the right to sell, lease, or rent any real property to whomever the owner chose. The amendment nullified the application of California's anti-discrimination statutes to real estate transactions. Lincoln Mulkey and his wife sued Neil Reitman, alleging that Reitman had refused to rent an apartment to the Mulkeys solely because of their race. Relying on Section 26, the trial court granted Reitman's motion for summary judgment. The Supreme Court of California determined that, on its face, Proposition 14 appeared neutral regarding private discrimination. Nevertheless, the court reasoned that Proposition 14 was specifically intended to authorize private racial discrimination in housing. By positively enshrining the right to discriminate in the California Constitution, the state had become excessively involved with private discrimination. The Supreme Court of California concluded that the excessive involvement violated the Equal Protection Clause. The Supreme Court of California reversed the ruling of the trial court. The United States Supreme Court then granted Reitman's cert petition.